Oh, weird. It's recording on a lag. That's visually very disturbing. So you make a gesture, and 2 seconds later, it shows up on the screen. Don't watch that. It can make you very dizzy. Yes? Eyebrows. You all have very expressive eyebrows. It's the highest compliment I can give. Expressive eyebrows. Some other time before class, we should talk about Kazakhstan, actually, which has been through some very interesting things lately, particularly in its relationship to China. But that's another discussion. You all heard of the Belt and Road Initiative? I actually had that was announced in Kazakhstan, and I actually had the privilege of being briefed like 2 days later. And at the time, no one had ever heard of it, so it was like really out of nowhere. And hearing this plan out of nowhere was startling. Just the scale of this thing. All right, back to law. So a little review. I think it's a good time for some review, because I think, A, you're working on the quiz. How's that going? Pretty good? All right. B, we've covered a lot of stuff, and I would not at all blame you if you're starting to feel a little bit drowning. It's a lot to keep track of. And C, not only pedagogically, that is not only in terms of how I want the class to work, but just in terms of historical development, the stuff we're talking about today is transition. It's a big transition from one way of thinking into a very different way of thinking. So it's a good moment to take a step back a little bit. At the very beginning, when we looked at the early periods, from the 1780s onward all the way up to the Civil War, in a way, there was simultaneously everything to talk about and not very much to talk about. And the reason, of course, was slavery. There was everything to talk about because, I'll repeat it again, slavery isn't an institution that consists of the violation of a right or a set of rights. It's a violation of all the rights. And as a matter of constitutional politics, because that was true, to have any kind of strong rights was impossible. And so in the sort of constitutional law sense, there was almost no constitutional law of rights. There couldn't be, except for a few. So we had Fletcher versus Peck and the right of contract, which is, of course, written into the Constitution. And we had a certain degree of solicitude for property rights as long as they didn't extend to everyone, right? And we had a lot of discussion about, I'm going to recharacterize what we looked at. If I were in a relatively cynical mood, which I am today, it wouldn't be entirely wrong to say that entire 100 years of constitutional development took the form of, well, if we ever do talk seriously about rights, how shall we talk about them? Right? Maybe someday we'll talk about this, and let's share some ideas. After the Civil War, and especially there's the Reconstruction Amendments, which is a period of tremendous ferment, tremendous change, and mostly what we saw there, and this is how I intended to tell the story, was a story of frustration. That is, there were forces, notably in Congress, that wanted to use the 13th, 14th, and 15th Amendments to be truly transformative, to dramatically expand the conception of rights to which Americans are entitled, which goes along with dramatically expanding the powers of Congress to protect those rights, because they're linked by 13.2 and 14.5. But there were counter forces, notably the courts. And the Supreme Court, in particular, in a whole series of cases, we read a couple and I pointed to some others just to make sure you understood it wasn't just those two cases, it was a whole pattern. Cruikshank and Slaughterhouse and all of those. Over a whole series of cases, the Supreme Court said, no, the 13th, 14th, and 15th Amendments are not going to establish a whole new regime of constitutional rights, a whole new understanding of what Americans are entitled to by virtue of being Americans. It's going to be applied as a narrowly defined equal treatment provision that focuses not solely, but pretty specifically on race, and only on very formal issues involving that, right? Field writes that dissent in Slaughterhouse, where he gives the alternative vision, but Field's alternative vision looks nothing like what you'd think of as modern strong rights theories. Field's concern is to use the 14th Amendment to protect a new set of theories of rights of what you might call rights of capitalism, economic rights. Rights to engage in economic activity without government interference. And he loses that argument, right? And I suggested that the reason he loses that argument at the time was because the majority, and Miller says this in his majority opinion, recognizes that recognizing even just economic rights, even leaving out all the other big issues that have been suppressed by the court already, recognizing those economic rights would require dramatically reconceiving the relationship between the federal government and the state government, and the relationship between the Constitution and the traditional concept of police powers. Now, is all of that familiar? On this instance, I don't care if it's boring and repetitive, as long as it's not strange and mysterious, because it's review. All right. Then came Plessy. Then came a lot of cases, right? But we looked at Plessy. And Plessy, on the one hand, very clearly, very strongly reasserted the court's position of clamping down on any argument that says the Constitution guarantees strong rights for Americans as individuals. Just shut that right down. That's not what we're about here. But it had that weird element, that weird language about the assumption that the Constitution requires all laws to be reasonable, to be enacted in good faith, to be for the public good, and not to be intended to annoy or oppress a particular class. And I pointed out that was a moment, of which we will see many more, or at least some more, where the court does one thing, like in this case, rules against the claim of rights of equality, but in the process articulates a language or an analysis or a test that will be picked up later for very different purposes. And I called your attention to that bit of analysis that Justice Brown engaged in. And I told you that even though it didn't have a name yet, that's the beginning of what is going to come to be called substantive due process. And today we're going to see what substantive due process means, like when it's made real. So in your notes, at the end of that first section about review, right, you'll notice I've jotted down those key terms from that bit of Plessy. They have to be reasonable. All laws have to be reasonable. Now pause for a second. Where in the Constitution do we find a principle that laws must be reasonable? Keep in mind, we are no longer in the 1780s. We're no longer in the period where saying something like that could be just a philosophical articulation. This is the U.S. Supreme Court saying this in the context of reviewing a law and contemplating striking it down. In other words, this is an assertion that courts should have the authority to find laws to be unconstitutional if, in the opinion of the courts, justices, they are unreasonable. Right? Okay, where does that come from? And it's very not obvious. Field had that broad notion that the Privileges and Immunities Clause bestowed the rights of freemen on all Americans. That's a light year away from saying justices can review a law, and if they don't think it's reasonable, if they don't think it's reasonable, that's a ground to declare it unconstitutional. Everybody see the difference? And good faith. Enacted in good faith sounds pretty harmless. You wouldn't want to say we accept laws enacted in bad faith. But what it implies is that the court has the authority to examine the motivations of the legislature and decide if they're being honest, if they're acting in good faith. Right? Which is another big step. Where in the Constitution is there a requirement that legislatures must act in good faith? It's a very odd requirement and very different from anything we've seen thus far as a matter of rights guarantees, isn't it? I have a right only to be subject to laws that are enacted by legislators who really mean what they're saying? That's a peculiar sort of right. And it doesn't really become a whole lot easier to get your head around if you say, no, it's a, right, in the model I've been using of rights as property versus rights as constraints on the form of government action. Okay, it's a form of government action, but where is good faith part of the form? Government actions don't put someone in jail without a trial. It's not subjective sincerity on the part of legislators. Imagine if in politics no one could lie. Politics would grind to a halt instantly. Lying is fundamental to politics. I don't even mean that in a sarcastic or cynical way. It really is. Not lying, misrepresenting, or not showing your hand. For the public good, right? The law has to be in good faith for the public good. Well, that requires a judgment as to what is and is not in the public good. I'm not being clever here. If you say this law is invalid if it doesn't serve the public good, then you're saying you're going to assess whether the law is serving the public good, right? That's an empirical question. That's a data question, a fact question. It's not a question of law. There isn't a legal principle of what is or does not serve the common good. And so immediately the question becomes deference. How much will courts defer to legislatures on empirical questions? We know, going all the way back to Marbury, actually long before, but in the standard telling, we referred to Marbury, and frankly, I don't have the energy to unpack all of the errors of legal history that infect our standard American narratives. We know, going back at least to Marbury, that on questions of law, courts will not defer at all. It is emphatically the province of the Judicial Department to say what the law is, said Marshall in that case. If the question is, what does the law mean? Courts decide that. You would never have a court saying, well, we think the First Amendment requires X in terms of free speech, but the legislature disagrees with us, so we'll let them decide. That's not out, right? We came close. I mean, there was a gesture sort of in that direction in McCulloch when Marshall, and this is not a topic that's not really our topic in this class, but it's an important one. There was a gesture in that direction in McCulloch when Marshall said essentially the scope of the powers of Congress are to be determined by Congress, as though courts have no active role to play in determining when Congress is acting ultra vires, if you remember that phrase, beyond the scope of its delegated authorities. But that's in a very different context. In terms of rights, never. But in the question of the public good, what does or does not serve the public good? Should courts defer to legislatures? Should courts, so we already have said courts will question the sincerity of legislators' announced motives. That's the good faith part, right? And we've already said the court will question whether the law is reasonable, whatever exactly that means. Allow me to help you understand what reasonable means. It's the opposite of arbitrary. There, now you know. That's it. I mean, seriously, that's as much definition as we have. And we have courts asking the question, does this really serve the public good? And on that last one especially, it should be obvious, but I'm hammering it repeatedly, obviously, that deference is a core concept. So what happens? The authors of your textbook say the 307 on the right, they try to describe kind of the different political attitudes, and it's a period, as I pointed out in the last time, the timeline that I put at the top of the notes. There's a lot of contestation. There's a labor movement. There are a variety of, the women's movement has started, movement for racial equality has started, organized labor has begun. Oh, I should have said that one already. There's an anti-labor movement. There's all kinds of conflicts. There's progressives and socialists, but also conservatives and Southern Democrats. Reformers insisted that modern industrial conditions justified far more regulation of business practices in the public interest than had previously been the case. Conservatives insisted that such regulations promoted the interests of one class of people at the expense of another, not the public good. That's a really key short paragraph there. It's worth unpacking a little bit. So one side, which the authors are calling reformers, and by reformers, progressives, what in modern era we would call liberals, in our modern use of the term, labor, certainly, populists, urged. Do you remember last time we saw a line from the Progressive Party's platform? Government is an instrument of good and should be used vigorously. That was one perspective. That's this perspective. We have a new situation. We have, in 1900, the world's first billion-dollar corporation, as I mentioned. In a world in which there are corporations that can employ 20,000 people and have $1 billion in asset. In other words, corporations are the size of a small country. We need new principles about what's permitted, about what government can do, what rights are for, and especially what role the government plays in regulating the operation of that economy. The old system of assuming that every transaction between two individual farmers, one selling apples to the other, might not apply anymore. And we saw various people taking that position in political speeches in previous lectures. So the claim there, and this is why the word progressive uses the word progress, change, moving forward, new things, novelty. New ways of doing things, the word new is key here. New ways of doing things, new circumstances, new parties involved, new empowered groups in the society, and therefore a new way of thinking about the Constitution is called for. That's that side of the argument. The opposing side, and the word conservative here is appropriate as long as you're very careful not to fall into the trap of thinking that conservative and liberal in this context mean what it means in modern partisan policy debates. The literally conservative position is the one that says we ought not to have change. That's what the term means. Conserve that which exists and which is valuable. And these conservatives say no. These kind of new regulations you're calling for are examples of class legislation, picking winners and losers, the government intervening in the economy to help one group against another. And this is bad. And we've seen repeatedly invocations of the idea of class legislation as being the mark of evil. And as I pointed out to you, very often the term class legislation was used to refer to legislation that enriched one group at the expense of another. In this period, we begin to hear about it used the other way as well, trying to empower, for example, industrial workers, and to limit the capacity of corporate employers to maximize their profits. It goes both ways, winners and losers, and not the public good. Right? That these are not laws that serve, in classical small r Republican sense, the public good. They're just interests, interest group politics. We are so accustomed to thinking that politics is supposed to be about interest group competition that it might sound a little strange to hear an argument made that that's somehow improper. But that's the kind of argument that's being made here. All right? Now, obviously, these are paper-thin arguments, if you lean on them even a little bit. Corporate interests are an interest group. U.S. Steel is an interest. Conversely, if you simply say that the existence of new conditions requires a new constitution, you've abandoned any claim to permanence. Right? You're risking reducing constitutional guarantees to nothing more than ordinary legislation. So either one of these positions, taken to any kind of extreme, is just sort of intellectually dishonest. But they accurately describe two currents of political discourse. So here's the New York's Supreme Court, which they call the Court of Appeals, and they do this just to confuse lawyers who are not from New York. Their actual Court of Appeals is called the, I forget what it's called, but their Supreme Court is called the Court of Appeals, just to mess with us. In a case, an earlier case, I don't have the year written down, talking about class legislation and why it is unacceptable. Such legislation may invade one class of rights today and another tomorrow. We will not, and then there's a slippery slope argument. Excuse me, that's actually my phone, which is embarrassing. No, I'm not going to answer. I'm just going to turn it off. Looks like a junk call. I get junk calls from trainees, which makes me feel very sophisticated and fancy. We will not be far away in practical statesmanship from those ages when government prefects supervised the buildings of houses, the rearing of cattle, the sowing of seed and reaping of grain, and governmental ordinances regulated the movements and labels of artisans, the rate of wages, etc. So if we allow this argument that we need new forms of government action in response to new economic conditions, it's a slippery slope. There's no limit. They could regulate anything. And he recognizes, whoever wrote this opinion, that there's historical precedent for that from those bygone days. Today, however, he says, a large range of affairs long since in all civilized lands regarded as outside of governmental function. Now, what's interesting about this argument is that, on the one hand, it's an appeal to traditionalism and conservatism. Let's not have new rules and new powers. On the other hand, if you read it carefully, he's appealing to a rather new idea of what government should not regulate. In the common law tradition, all of these things were subject to regulation. Police powers. Police powers was about exactly regulating all of these things. When the Puritans formed settlements in Massachusetts in the 1600s, among the first laws they passed were laws setting wages, determining the sizes of and purity of loaves of bread, the strength of beer, who could own a gun, who needed permission to use a canoe, and who was allowed to trade with Indians. And that was a small portion of an enormous regulatory scheme. The idea that there were limits to police powers only emerges in 1870. So here's this interesting twist to this whole debate. The conservatives who are appealing to ancient traditions are appealing to ancient traditions that are less than 50 years old, often less than 30 years old. But the idea, this is Field's idea, right, is that the 14th Amendment took what had previously been thought of as restrictions on the powers of the national government, or some version thereof. It's a little bit as though states now have only enumerated powers. Think about it. If states can only exercise traditional powers and not new powers, that's a theory of enumerated powers. You were given certain powers. Those you made a different process. It wasn't by Article 1. It was by historical understanding. But you were given certain powers, And those are the only ones you may exercise. If you exercise any more, you'd be acting ultra vires. It's a very useful phrase, that phrase. But the irony is, of course, that prior to 1870, there was no such notion of any such limitation on state and local police powers. I could go on. In the 17th and 18th century, local laws regulated families, told wives and husbands they had to live apart, or told wives and husbands they had to get back together because they were quarreling and upsetting the neighbors. There was nothing that was outside the scope of police powers in its historical understanding. So, big radical idea. 14th Amendment means there are limits to police powers. Problem is, it's not clear how to understand what those limits mean. Here are two possibilities. I've already alluded to one of them. Here are two intellectually plausible possibilities. So I've already alluded to one which goes like this. Through a process of historical development, states have been given certain powers. Something very close that looks a lot like enumerated powers in Article 1 that are given to the federal government. States may exercise those powers. Those are real police powers. If states try to do new things or different things or other things, that is prevented by the 14th Amendment. We still haven't explained why. What in the 14th Amendment would possibly have that implication, but that's one way of arguing. A different way of seeing the same argument. States' police powers didn't used to have limits. It was just a general name for the fact that we let towns and cities and states make rules. It was just a name for a practice, not a formalized theory of particular and specific powers. And it varied from county to county and state to state and different parts of England and so on. I swear I thought I turned that thing off. I don't want to smash my phone. I hate technology. That's not true. I love some technology. Some of my favorite things get plugged in. Right, second way of reasoning, batteries, stop it. The second way of reasoning is to say, no, the old phrase police powers wasn't the name of a specific set of enumerated or delegated powers. It was this general principle. We have local regulation to do what people think needs to be done. Only the federal government, the new invention of the Constitution, only that was given limited enumerated powers. And from that perspective, what we have here is new limitations on police powers. Which of those or something else accurately describes what's going on? And I've given you a whole series of cases again that we're not going to dig into. But again, the purpose is just to show you the range of arguments that were floating around, and then I'm going to try and make sense of them. But for example, Munn versus Illinois, 1877, so right in the same period, you have a strong recognition of police powers. And in fact, of the expansion of police powers into a new context, grain elevators. Have we talked about Munn versus Illinois? I explained about the railroads and the grain elevators? Okay, real quick. So some people wanted yes, some people wanted no. I suspect some people remember this from a previous class or something. It's one. My dissertation was, to a certain large extent, focused on railroads, things like this. This is my thing. The area of the Old Northwest, Ohio, Wisconsin, Michigan, Illinois, when they were first settled, it was almost impossible to grow things. The land was incredibly fertile, as it is today. There were two problems. One, when people arrived in the prairies of Illinois, it was covered with weed growth 10 feet high, wild grasses. And clearing that was very, very difficult. It took a great deal of effort. It was very hard to have to clear that stuff and plow the land. Two, mud. Travelers like Charles Dickens, Dickens wrote about this, talked about seeing a stagecoach sunk into the mud to the point where only its roof was showing. Once you cleared off all that growth, and you got all that wonderful, incredibly rich farmland, and it rained, it turned into bog. And so you could grow stuff, but you couldn't take it anywhere because the roads were impassable. And you couldn't grow very much stuff because it was really hard to clear and plow the land. In 1837, two technological innovations occurred in the same year. The John Deere plow, the Prairie Queen. I know this is not relevant, but I can't resist, I'm sorry. The John Deere plow was a plow with two blades, and a main blade and a wheel and a small second blade that scoured the first blade as it went, scraping the mud out of the plow as it went forward, enabling it to cut down all that growth and dig up that earth. And with the John Deere plow, you could suddenly grow far more than anybody could possibly eat and was suitable for export. But there's still the problem of getting it anywhere. Enter the railroads. Railroad beds built on top of the earth could operate despite the muddiness when periods of ordinary roads were utterly impassable. Both in the same year, 1837, which is also the same year that half a dozen states go bankrupt. There's a lot going on that year. It becomes the case that it's highly desirable to have a place where all of these rail cars full of grain can come together and unload onto barges going through the relatively recently constructed Erie Canal to take them east to the East Coast. In fact, it's so useful that there be such a place, they actually build a town, and they call it Chicago. Chicago is where it is for no good reason. The land is terrible. It's built on sand. They have to dredge the harbor every couple of years. I don't know if you noticed this, but about 5-6 years ago, the sewers started to collapse because the entire city of Chicago is built on soft, shifting, unstable ground, and it's a terrible natural harbor, but it's a perfect location for rail lines to meet barges. And they built these things called grain elevators, in which these giant towers on bridges over the Chicago River, the barge would pull up under the tower, and you would just dump the grain from the tower into the barge, and away it would go. And it changed everything. For one thing, you were no longer buying grain from a particular farmer. You were buying grain from hundreds of farmers. And so you were no longer buying John Smith's grain, you were buying graded grain. There was grade A corn, grade B corn, and grade C corn. And it didn't matter who grew it, you bought it by volume, I want 5 tons, and grade of grade B corn. Yeah, that's a lot. Of grade B corn. European travelers were astonished and shocked at the volume of grain that passed through Chicago. It was mind-blowing compared to any European market that they were used to. Everything went through those grain elevators. One of the things that happens is you no longer are making contracts with a farmer, Farmer John Smith, I will buy whatever grain you grow next year. You're making a contract with a grain elevator operator, I'll buy a ton of grain at this price. So suddenly, it's a commodity trade. And out of that come the grain, the futures receipt, an advanced purchase, a year, 6 months in advance to buy a fixed amount of grain at a certain grade. Out of that comes the commodities exchange at the beginning of the stock exchange. All of that comes from these grain elevators. Illinois wants to pass a law. And the law says you've got to act as a common carrier. This is why that common carrier concept is so powerful and so important. Long before we get to questions of whether you can desegregate restaurants, because it's a place of public accommodation. It's used for grain elevators. You must treat all trains the same. The trains must treat all farmers the same. You must treat all buyers the same. Standardized prices, standardized grades, and standardized terms of storage and shipment. And this is challenged as violating the 14th Amendment. And in Munn versus Illinois, the Supreme Court says that the grain elevators are, quote, clothed with a public purpose. They stand at the very gateway of commerce and take a toll from all who pass. So this is expanding the idea of common carriers to new categories. Grain elevators didn't exist, nor was there anything remotely like them. These aren't ferries or toll roads or hotels. In this context, in 1877, the Supreme Court is perfectly willing to expand the scope of police powers to cover new situations, new technologies, new economic relations, applying classic principles, the common carrier principle, but to a brand new situation. So great, you say. Aha, the progressives win, the Supreme Court turns out to be progressive after all. They're into new applications of new ideas. Well, not so much, because in Chicago, Minnesota, and St. Paul Railway Company versus Minnesota, in 1890, 13 years later, this is now the Fuller Court, Chief Justice Fuller uses that phrase, this is not the first time, substantive due process. And he says, and he reiterates that point that was sort of buried in Plessy, but wasn't used. The question of the reasonableness of a rate of charge for transportation by a railroad company is eminently a question for judicial investigation. Right? It is appropriate for courts to ask what's a reasonable price to charge for hauling freight on a railway. What do judges know about the appropriate prices for hauling freight on railways? I'll give you a hint. It's not taught in law school. It's not as though there's a course on, by the way, here's pricing mechanisms and market conditions and, right? Requiring due process of law for its determination. Okay, now we hit it. How do you get from the 14th Amendment to the principle that says courts can strike down laws if they're not reasonable? And the answer is the Due Process Clause, and that takes a little explanation. I said last time, if I just wrote on 3 note cards, the Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause, I think you'd have very little trouble figuring out what they mean. The Privileges and Immunities Clause, like Field said, is about a set of rights that everybody has. The Due Process Clause is about the way government does things, the procedures. Did you touch second base? I'm not trying to minimize the importance of that, but did you follow the rules? Did you follow the procedures? And the Equal Protection Clause, that's where you'd find some principle about treating people the same, right? So how do you get to the Due Process Clause? I can give you a couple of possible answers. Oddly, I don't know of a case or a treatise which has ever really clearly embraced one of these explanations. But let me give you my favorite, what I think makes the most sense here. Due process of law obviously comes into play when the law is being applied. So if we say you have a right to a lawyer at a trial, that's part of the process that is due in that situation. Why don't we use the same procedures for parking tickets that we use for murder convictions? Nothing in the Due Process Clause says it's relative, more for one, more process. Well, the word due, what degree of process is due, varies depending on the severity of the possible outcome. If every parking ticket could be contested with a court-provided lawyer and appeals up to the Supreme Court, right, it would be insane. If murder convictions could be applied with the ease of parking tickets, it would be intolerable. You have to have a theory of proportionality, even at the most procedural understanding of due process. But of course, the instant you acknowledge that there's some sort of principle of proportionality involved, you're starting to judge the significance of the penalty the law imposes, of the action that the intervention that the law represents on social behavior. And that raises the possibility that perhaps some interventions are simply impermissible. We already have the name of one, a law passed to annoy or oppress a particular class. This will later be called the bare animus theory. A law that is passed on the grounds that we don't like your kind violates the Due Process Clause. Why? Because process applies not only to the application of law, but to the making of law. Due process in law making, right? Due process in law application means how much process is due depends on how severe is the possible consequence of the application of the law. Due process in law making means what kind of criteria and justifications a legislature may rely on depend on the severity of the intervention that the law threatens in social life. This becomes the idea that certain kinds of laws need more justification than other kinds of laws. Speed limits don't need a lot of justification. If you say we're setting the speed limit at 65 on this road, and someone says, well, I think it should be 64, nobody's going to care. There are other kinds of laws we care about a lot more. So a law that imposes that is unreasonable or arbitrary doesn't meet the minimum level of justification. Even a speed limit, by this logic, can be unreasonable or arbitrary. Well, how would you argue that a speed limit is unreasonable or arbitrary? You might make an empirical claim. You, the legislature, have gotten the relevant speed wrong. You set it too high or too low. That's difference on empirical justification, right? You see how this ties into what we were talking about before? Did you pass this law just because you hate the people in that neighborhood? That might be a bare animus situation. Did you claim this law, this speed limit, served public safety, but really what you wanted to do was, I'm trying to think of a good example of the speed limits. I really have to make these things up ahead of time. You're really trying to clamp down on the sale of sports cars, because if nobody can drive over 60 miles an hour, nobody's going to want a sports car. Right? It's a pretext. You're lying. You're not acting in good faith. All of those can come up in talking about a speed limit. And the idea is those are questions captured in the Due Process Clause. Let me read it to you again. The question of the reasonableness of a rate of charge for transportation by a railroad company is eminently a question for judicial investigation, requiring due process of law for its determination. All right, so that's what happens. Courts, under the idea of substantive due process and particularly a principle called liberty of contract. The Due Process Clause says no one may be deprived of life, liberty, or property without due process of law. We agree, for our purposes, that due process of law applies to lawmaking as well as law application. Then liberty becomes a key point, and the argument in this period is that liberty includes economic liberties, the freedom to engage in economic relations as you see fit. What does that do to police powers, though? Suddenly, police powers are only legitimate if they're reasonable, which is a new constraint. And the question will be, what defines reasonable? So a few examples. Allgaier versus Louisiana, 1897, a law limiting the sale of insurance to companies registered in the state is ruled unconstitutional. An unreasonable, arbitrary deprivation of liberty for insurance companies from other states. Adair versus United States. This is a right to work decision for striking down laws. So employers, confronted by the possibility of unionization, adopted policies saying if you belong to a union, you can't work here. Louisiana passed a law saying, no, you can't have those rules in your contract. Supreme Court says, yes, they can. They have to be allowed to have those rules. That's part of the freedom of contract. It's not reasonable to say that you have to be willing to hire union employees. After all, 309 on the left at the top, in all such particulars, the employee and the employer have equality of right. And any legislation that disturbs that equality is an arbitrary interference with the liberty of contract, which no government can legally justify in a free land. 4 phrases: arbitrary, liberty of contract, no government, meaning no degree of interference, is acceptable, and free. This has something to do with our basic notions of what it means to be free. Cobbett versus Kansas, similar to Allgaier. On the other hand, there are cases which regulations are upheld. A safety rule in Bunting versus Oregon, a limit on women's hours in laundries in Miller versus Oregon. But then in 1923, back again comes Atkins versus Children's Hospital and strikes down a minimum wage law for women. To set a minimum wage is unconstitutional. Why? It interferes with the liberty of contract for workers and employers to negotiate salaries, and to interfere with that liberty is unreasonable. Notice unreasonable becomes tautological. To interfere with certain liberties is by definition unreasonable. In other cases, it depends on the empirical judgment of whether the application of this particular rule is unreasonable. With me so far? So the question you should be asking is, what's going on here? What connects these different rules? Right? I can point to some ideas, right? And the answer is Lochner versus New York in 1905. This is the only case I know that gives its name to an era of U.S. constitutional development. I mean, you've all heard of Brown versus Board of Education. That's a very important law, but no one talks about the Brown era. Talk about the Warren Court. We always talk about courts, right? The so-and-so court, depending who's Chief Justice. Only the Lochner era is named for a case. That's how important this case is. The case involves a law setting limits to working hours in bakeries. 10 hours a day, 6 days a week is the most that anyone may contract to work in a bakery. Peckham is the name of the justice who writes the majority opinion. It's a 5-4 majority. Notice this incredibly central, incredibly important ruling would have come up the other way with one different appointment. And that happens consistently through our history. I mention that as to caution you about 2 things. One, never forget how much politics has to do with the constitutional politics. Never forget how much constitutional politics has to do with constitutional law. And never forget that principles and precedents and rules that seem to us graven in stone might actually have been gone the other way with a slight change in circumstances. So he starts with declaring the substantive due process right to liberty of contract. The general right to make a contract in relation to his business is part of the liberty of the individual protected by the 14th Amendment. Can the states make any rules? Sure they can. Police powers. Right? These familiar concepts, and he's just going to run through them. There are certain powers existing in the sovereignty, and notice the importance of the sovereignty of the state here, that federalism question. The sovereignty of each state in the Union, somewhat vaguely termed police powers. Remember how repeatedly people said there are fundamental rights, but we're not going to bother to list them? We've also heard, well, there are police powers, but we're not going to bother to list them. It's a vague term, right? As I said, one reading is, police powers just generally means regulate whatever you want. Maybe that's all it meant. There are powers existing in the sovereignty, inherent in the sovereignty, not enumerated, not granted, of each state, somewhat vaguely termed police powers. the exact description and limitation of which have not been attempted by the courts. Oh well. Both property and liberty are held on such reasonable conditions as may be imposed by the governing power of the state in the exercise of those powers. So the test, regardless of which version of the new approach to police powers is intellectually more accurate, the delegated powers model or the no novelty model, the test is going to be couched in terms of reasonableness. So police powers only extend, right? This is exactly what we saw in Plessy. This is exactly what I just read to you from Allgaier. It's just being stated a little bit more clearly now. The phrase police powers means the power of the states to enact reasonable regulations. It does not mean the power to enact unreasonable regulations. What's the judicial test? Well, we already said courts are going to ask this question. In every case that comes before this court, the question necessarily arises. Is this a fair, reasonable, and appropriate exercise of the police power of the state? Or is it an unreasonable, unnecessary, and arbitrary? Remember I said the reasonable means not arbitrary? An arbitrary interference with the right of the individual to his personal liberty, or enter into those contracts in relation to labor which may seem to him appropriate or necessary for the support of himself and of his family. I mean, one has to love the way this is presented as protecting the worker. Workers must have the right to work 70 hours a week or whatever is the issue. Right? So in every case, courts are supposed to look at a law that's being challenged and ask, is it reasonable? Is it fair? Is it appropriate? All of that comes out of the 14th Amendment. All right? Now let's apply that to the case before us. So we have a law limiting the number of hours that a baker can work in the state of New York. Is that law reasonable, fair, and appropriate? The question whether this act is valid as a labor law, pure and simple, may be dismissed in a few words. There is no reasonable ground for interfering with the liberty of person or the right of free contract by determining the hours of labor in the occupation of a baker. That is the key sentence in this opinion, and it's one that's very easy to overlook. I think people often do overlook it when they talk about the Lochner case. So, we've already said that police powers exist, that states have the authority to make reasonable regulations in the promotion of public safety, healthy, welfare, and morals, right? As long as they're reasonable, fair, and appropriate. So how can we, in one sentence, without any analysis or discussion, say that this one doesn't qualify? And the key is the phrase, labor law, pure and simple. If the purpose of this law is to regulate labor relations, relations between employers and employees, then it is necessarily and by definition unreasonable. Put another way, police powers do not extend to the regulation of economic relations as such. Now, why am I saying as such? Because it's perfectly possible, and this goes back to those cases with the differing outcomes we looked at, it's perfectly possible to justify regulation of an economic relation if that's incidental to a real exercise of police powers like health and safety. So it's perfectly okay to have rules regulating the conditions of work if that's in good faith, reasonably adopted in support of public health and safety. It is by definition not okay. There can never be any such justification for regulation of labor relations or economic relations per se. And the huge question is going to be why. I'm going to come back to that. Let's just spell out what the rule is. So if it's a labor law, if that's all it is, if it's just a law because the legislature doesn't think this is a good labor practice, it's unconstitutional. Well, could there be a police powers justification? For example, is it possible that bakers are weak, vulnerable persons who need special protection? Wards of the state? No, says the court. There is no contention that bakers as a class are not equal in intelligence and capacity to men in other trades or manual occupations, or they are able to assert their rights and care for themselves without the protecting arm of the state interfering with their independence. Right? We protect children. We protect vulnerable people. But these are adult male bakers. They need no such special protection. They are not a vulnerable class. The point is, that would have been a perfectly legitimate police powers justification. If bakers had been a vulnerable group, if these had been children, that would be a perfectly valid police powers justification. But if it's not that, if it's just regulating labor, Viewed in the light of a purely labor law with no reference whatever to the question of health, we think that a law like the one before us involves neither the safety, the morals, nor the welfare of the public. That the interest of the public is not in the slightest degree affected by such an act. There is no public interest in regulating wages, working hours, and economic relations. Hold on to that concept. It's a key claim. Notice there's also no moral claim here, allegedly. Morals, the authority of the state to pass rules to preserve public morals, doesn't extend to dictating the terms of economic behavior. All right, could it be a health regulation? There's a good police power justification. If this was a matter of protecting health, that would be fine. And the fact that you're in the process of protecting health, regulating economic relations, would not be a problem. But no, we think there can be no fair doubt that the trade of a baker in and of itself is not an unhealthy one to that degree, which would authorize the legislature to interfere with the right of labor and the right of free contract. And this opens up a really interesting can of worms. This is about that question of deference on empirical questions. The court is declaring that baking is not an unexceptionally unhealthy occupation. The trial court received an enormous amount of evidence that it was. There's a condition called brown lung that comes from breathing flour dust. It's a lot like coal miners' black lung. Bakers died very young from the corrosive effects of flour dust in their lungs. But that's not the point. That is, the point is it appropriate for a court to second guess the legislature on this question? If the legislature says, we think baking is unhealthy, under the what the reasonableness review requires is it requires the court to ask, did they get that right? That empirical, scientific, medical, however you want to characterize it, that fact question. It's not a law question. There isn't a law that says baking is or is not unhealthful, right? And the justification that is offered is that, well, if we allowed the legislature to say that this activity is unhealthy, slippery slope, they might be able to say lots of things are unhealthy. They might be able to regulate lots of things. It is unfortunately true that labor, even in any department, may possibly carry with it the seeds of unhealthiness. Are we all on that account at the mercy of legislative majorities? A printer, a tinsmith, a locksmith, a lawyer's or a physician's clerk. The lawyer's part is particularly pointed, right, to the people reading this. Or a clerk in almost any kind of business would all come under the power of the legislature on this assumption. So we will not defer to the legislature. We will decide whether what you're regulating is such an extremely and uniquely unhealthy profession that you should be allowed to regulate it, and that's reasonable, or whether it's just like lots of other professions, in which case what you're doing is unreasonable. Why is that unreasonable? Not because it's wrong, not because the work is not unhealthy, but because if we let you say that was unhealthy, we'd have to let you say lots of other things might be unhealthy. We would be allowing state police powers to operate without effective limitation. And he continues the argument. It's a core of his argument. It might be said it is unhealthy to work more than that number of hours in an apartment limited by artificial lighting. That the occupation of bank clerk, the lawyer's clerk, the real estate clerk, notice how he's emphasizing what we now call white-collar jobs. Right? Don't think this is just about industrial workers. They'll come for you next. Is therefore unhealthy, and the legislature in its paternal wisdom must therefore have the right to legislate on the subject. So that's the end of that argument. And notice what he did say and what he didn't say. He didn't say baking is healthy. He said we, the court, don't think baking is so exceptionally unhealthy that it justifies legislative intrusion. And we say that because if we didn't insist that only exceptionally unhealthy occupations may be regulated, occupations generally might be subject to police powers regulation for the health, safety, welfare, and morals of the people. What about public health? Is there a public health argument here? It is urged, pursuing the same line of argument, that it is the interest of the state that its population should be strong and robust. So one was an individual baker might be vulnerable to being unhealthy. This is now the collective argument. We want people to be generally healthy. We want our population not to have lots of diseases, to increase medical. Think of debates about medical insurance, health insurance, right? One argument you hear often is, well, if people engage in unhealthy activities, they impose costs on the system, right? Because they need more medical care. You've heard these kind of arguments, haven't you? Okay. So that's the public health argument. That's saying, well, you should make this policy because we have a general interest in preserving public health. It is urged, pursuing the same line of argument, that it's the interest of the state that its population should be strong and robust. Is that a good argument? Well, there might be a valid police power's interest in having a strong, healthy population, but we can't accept such an argument because if we do, there would no longer be limits on police powers from the 14th Amendment. Scarcely any law but might find shelter under such assumptions. Not only the hours of employees, but the hours of employers could be regulated. Doctors, lawyers, scientists, all professional men, as well as athletes and artisans, could be forbidden to fatigue their brain and bodies by prolonged hours of exercise. Is there an issue of the quality of bread? That would work. If the law in question, so the law about working hours was actually part of a larger scheme. There are about 28 elements to this scheme. Only 2 of them were challenged, hours and overtime wages. All the others had to do with cleanliness, ventilation. Those were all upheld. None of those were challenged. Those were all accepted as valid police powers. Because you could argue they had to do with the healthiness of the product, right? Or the immediate healthiness of the worker. In our judgment, it is not possible to discover the connection between the number of hours a baker must work and the healthful quality of the bread. Right? Maybe you can justify something like, please stop putting gravel in your bread to protect the public health, but nothing about the healthfulness of bread is affected by limiting working hours. And part of the reason is that the legislature has chosen a specific limit, and any specific limit can be questioned as arbitrary. If a man works 10 hours a day, it is all right, but if 10 and a half or 11, his health is in danger and his bread may be unhealthful, and therefore he should not be permitted to do it, this, we think, is unreasonable and entirely arbitrary. The question, of course, is then why can we have speed limits? Or age restrictions? Does anybody think that a rule saying you can't buy alcohol until you're 21 can be defended as being more justifiable than a rule saying if you're 20 and a half, or 21 and a half, or 22? Obviously not, right? Obviously it varies by individual cases. Obviously these rules in application are going to be arbitrary. Why does it matter that this one is arbitrary? Because, unlike buying alcohol, determining your own hours and wages of labor is part of the liberty of contract in substantive due process. So it still has that slaughterhouse bit. There has to be a fundamental right at stake. And the right we're describing is liberty of contract. So where liberty of contract specifically is at stake, this kind of scrutiny is triggered. How do you explain Plessy? There was no fundamental right. The right to ride on a rail car in a non-segregated car is not part of liberty of contract. And therefore it's not protected by this test. And there's a passage that the authors left out of the book, which I think is extraordinarily important, which provides the political context for this discussion. All those slippery slope arguments, right? What they're about is, these are conservative judgments afraid of creeping socialism. They're afraid the socialists and the progressives and the populists and the labor unions are going to bring on foreign ways of doing things. It is impossible for us to shut our eyes to the fact that many of the laws of this character, while passed under what is claimed to be the police power, and that's a pretext, a good faith argument. You claim you're exercising police powers, but we're going to second guess. We don't believe you. We're going to test your honesty here. Under what is claimed to be police power for the purpose of protecting the public health are in reality passed for other motives. The motive of the legislature is key. And the way you fail this test is pretext. We are justified in saying so when from the character of the law and the subject upon which it legislates is apparent that the public health or welfare bears but the most remote relation to the law. You've got a law that claims to be a public health regulation. We don't believe, as an empirical matter, that health is at stake. Therefore, we're going to conclude it's a pretext, and you're lying and you're really trying to do something else. The purpose of a statute must be determined from the natural and legal effect of the language employed, and whether it is or is not repugnant to the Constitution of the United States must be determined from the natural effect of such statutes. This is substantive judicial review. This is courts reviewing statutes and saying, do we believe that you're being honest about your motives? Do we accept your empirical conclusions about what does or doesn't serve things like the public health or any other legitimate public purpose? Do we think you're engaging in trying to make class legislation to oppress one group or benefit another? And if you fail those tests, that is grounds for us to declare the law to be unconstitutional. It seems to us the real object and purposes were simply to regulate the hours of labor. This wasn't a health regulation at all. It was a sneaky attempt to regulate working conditions between master and employees in a private business. Under such circumstances, the freedom of master and employee, to contract with each other in relation to their employment cannot be prohibited or interfered with without violating the 14th Amendment. All right, that's the majority opinion. I'm going to come back to say something about that and try to make sense of it, because there's a standard way of telling the story, and by now you won't be surprised to know that I think it's wrong, and a different way of telling the story. But first, let's look at the dissenting opinions. Harlan, known as the Great Dissenter, remember from last time, he also dissented in Plessy. Harlan says, look, your approach is fine. I totally agree. We should ask whether laws serve the public good. We should ask whether laws are pretexts for improper motives. We should do all of this analysis. But on questions of fact, on empirical questions, we should defer to the legislatures. It's up to the legislature to decide, particularly if there's a debate. This is an uncertain question. Is baking really unhealthy? Right? We have no warrant to overturn a legislature's decision one way or the other. One legislature might say, yes, baking is super unhealthy. One might say, no, it's not. That's up to them. That's the kind of question legislatures should decide, not a question courts should intervene in order to prevent the adoption of economic policies. Granting there's a liberty of contract, but assuming such liberty of contract is subject to such regulations as the state may reasonably prescribe for the common good, it's the same test. Harlan is not disagreeing with the analysis, just its outcome. What are the conditions under which the judiciary may declare such regulations to be in excess of the legislative authority and void? It's all about what's the scope of judicial review. If there be doubt as to the validity of the statute, that doubt must therefore be resolved in favor of its validity. If you're not sure whether there's a genuine issue of health involved in limiting the workers of bakers, you, the judge, have no warrant in declaring the law unconstitutional. It's not a legal question. It's not a court question. If the end which the legislature seeks to accomplish be one to which its power extends, right? So the end is public health, and the means employed to the end, although not the wisest or best, are yet not plainly and palpably unauthorized by law, the court cannot interfere. That should sound familiar. Do you recognize that language? That's Marshall and McCulloch. Let the end be legitimate, and the means not plainly outside what is permitted by the Constitution. Courts have no legitimate role to play in striking down legislation just because they disapprove of it. What about this idea that, well, maybe they really weren't concerned with public health? Maybe they were just trying to regulate working hours because they wanted to have workers be protected against employers, right? This whole labor relations thing. It may be the statute had its origin in part in the belief that employers and employees were not upon an equal footing, right? You have massive corporate employers, and during this period, courts are striking down, making decisions that make it unlawful to form unions. So even when legislatures try to allow unionization, the courts strike them down. Right? So one argument is, aha, you have collectivized employment, corporations, and you don't allow collective activity by the workers, therefore it's unequal, therefore the legislature should be allowed to step in. Maybe, says Harlan. If that were true, that would be a problem. He agrees. That's not a good thing for courts, for legislatures to do. But be that as it may, the statute must be taken as expressing the belief of the people of New York that as a general rule, and in the case of the average man, labor in excess of 60 hours during a week in such establishments may endanger the health of those who thus labor. Maybe you're right. Maybe there's a secret desire here to adjust the relations between employer and employee, but it doesn't matter. The law passed by New York says this is a matter of public health, and unless you, the court, can conclude that it is plainly and palpably not the case, you have no warrant to second-guess that judgment. And you don't have a warrant, he's saying, to look deep into the subjective motives of legislators. What were they really thinking? You have to take the proclaimed justification at face value and defer on the question of fact. What the precise facts are may be difficult to say. It is enough for the determination of this case, and it is enough for this court to know that the question is one about which there is room for debate and an honest difference of opinion. If there's room for differences of opinion, it's not up to this court to decide that one side is right and one side is wrong. All right, so Holmes' dissent meets the majority squarely on their own grounds, accepts the analysis, accepts the premises, right? But says you should defer. You should defer on the question of what is the motivation of the legislature, and you should defer on empirical questions such as how unhealthy is baking. Holmes' dissent is one of the most famous opinions in the history of the U.S. Supreme Court. As I think I've already suggested about Holmes, he often writes things that are irresistible and irrelevant. You cannot take Holmes' dissent literally. On the other hand, you cannot ignore the strength of his basic point. Let's see what I'm talking about. And you can decide if you agree. Holmes says, look, it's not the legislature that's hiding its motives, it's the court. It's not that the legislature is hiding a secret desire to adjust labor relations. The court has a desire to impose laissez-faire, a political philosophy that prevents legislatures from adjusting labor relations. The only justification for that is ideology, preference. This case is decided upon an economic theory which a large part of the country does not entertain. If it were a question whether I agreed with a theory, I should desire to study it further. But I do not conceive that to be my duty, because I strongly believe that my Supreme Court Justice talking, right? My agreement or disagreement has nothing to do with the right of a majority to embody their opinions in law. You can't strike down laws because you think they're stupid or wrong or bad economics. That's not our job, says Holmes. After all, a constitution is not intended to embody a particular economic theory. Pause. Is that true? Think of the centrality of property rights to the constitutional text, as well as the body of decisions that have interpreted its meaning that we've worked our way through. Are there not assumptions about particular economic theories bound up into those constitutional provisions? And notice, by the way, if you say that there are, if you say, for example, private market capitalism is intrinsic to the U.S. constitutional order, then if there were a change in the economic order, that might call for a change in the Constitution. There was no such thing as corporate capitalism in 1787. There was no such thing as investment in corporations. There was no such thing as a private entity that had tens of thousands of employees and millions or billions of dollars in assets and controlled the operation of prices across the entire country. If that changes, right, if you make the one argument, our Constitution embodies certain economic conditions, that kind of points to that if economic conditions change, so does the Constitution. That's not where Holmes wants to go. Holmes wants to say there is no commitment to any particular economic theory in our Constitution. And he wants to make that argument based on what he will, in a different context, call the marketplace of ideas. It is made for people of fundamentally differing views. And the accident of our finding certain opinions natural and familiar, or novel and even shocking, ought not to conclude our judgment about the question whether statutes embodying them conflict with the Constitution of the United States. Unless it can be said that a rational and fair man necessarily would admit that a statute proposed would infringe fundamental principles as they have been understood by the traditions of our people and our law, we cannot proclaim a law to be unconstitutional under the 14th Amendment. It does not need research to show that no such sweeping condemnation will be passed upon the statute before us. Okay, strong, this is, and people call this, Richard Posner has called this the greatest opinion ever written. Lots of people say, how could I possibly be snarky about this opinion? Here's the problem. First of all, the strength of the opinion clearly is correct. That is clearly, or that's the wrong way to put it, isn't it? Is powerfully persuasive. There's a powerfully persuasive case that it is not the job of people trained in law to make decisions about what is good and bad economic policy. What does or does not serve the public good in terms of public health. What level of, I'll pick an example, what level of pollution in the air should be allowed. Right? It's not something judges are trained to decide. And it's not part of their job description. Article 3 says nowhere that the court, right? You're familiar with that argument. So what's wrong with this? Why am I being snarky about the sainted Holmes? Because he can't possibly mean we should be as deferential as he says. He can't possibly mean that no theory is unacceptable, that our Constitution is literally value neutral after the 14th Amendment, that anything passed by the majority must be okay, unless, how did he put it? A fair and rational man would necessarily conclude. Look at the burden of persuasion that implies. Well, back to the majority opinion. What's going on? Now, when I was in law school, and by the way, for about 80 years, around the time I was in law school, most of it before, I'm not that old, the answer was simple. The majority in the Lochner court was a bunch of ruthless, laissez-faire capitalists whose only concern was to screw the workers and support capital, and it's all class warfare, and that's the explanation. The problem with that explanation, well, A, I've already pointed out, there are lots of cases where they upheld regulations, right? And we're about to see another one. So it's simply not the case. There were in the state courts judges who were true laissez-faireists who tried to strike down every economic regulation of every kind. But that's not what goes on in the Supreme Court at all. Furthermore, I've tried to urge you not to only look at who wins and who loses, but also look at what's the logic, what's the argument, what's the rule that might get used in a future case. And you certainly can't reduce this analysis. The only way to say this is just about rich versus poor or just about laissez-faire is to ignore everything that's said. And that doesn't seem to me to be a plausible way of reading this opinion. Mueller versus, well, I was having fun with Lochner when I took too much time. I do have fun with Lochner. Mueller versus Oregon really quickly, and then I'll come back to this question of what I think is really going on. 1908, 3 years later, Oregon passes a law limiting the working hours of women in laundries. Right? First one was men in bakeries. The only difference, different sex, different occupation. Right? This law is upheld 9-0, which makes it tough to claim this is sweeping laissez-faireism, doesn't it? I mean, it's not unrelated maybe, but Holmes' description that this is just imposing laissez-faire doesn't. All right. Here's another interesting thing. Compare the majorities in Plessy and Lochner. You remember Plessy, right? Same era, 8 years earlier. In Plessy, Brown, Fuller, and Peckham all voted to uphold the segregation law. In Lochner, Brown, Fuller, and Peckham all voted to strike down the law limiting working hours. So the core, the conservative core, described as conservative, core of the court believes that the Plessy law was appropriate and the Lochner law was inappropriate. How do you explain both of those? Back to Mueller versus Oregon. So in Lochner, a really key and crucial point was deference on questions of empirical fact and whether courts should accept legislature's word for it as something as unhealthy. A lawyer named Louis Brandeis said, "You want to play that game? Let's play that game." And he filed what came to be known as a Brandeis brief, a kind of brief never seen before in the federal courts. 2 pages of legal argument, 15 pages of statutes from various states and countries, showing that women working in laundries often had their hours regulated, and 95 pages of medical studies. This is at the Supreme Court. Remember, the Supreme Court doesn't decide fact questions at all. It's only supposed to review what lower courts have done and say, did they make an error in the law? But the Lochner majority made it clear that's not how they viewed their mandate anymore. They were going to dig into the facts of the matter and make their own decisions. And the problem was none of the lawyers understood that. No one knew you could put factual studies in a Supreme Court brief. Brandeis figured it out from Lochner, so he files this massive thing. He argues, we submit that in view of the facts set forth, and of legislative action extending over a period of more than 60 years in the leading countries of Europe and 20 of our states, right? This is traditional, this is widespread, this is not new, this is not novel. It cannot be said the legislature of Oregon had no reasonable ground. It can't be unreasonable to do something that is a widespread traditional practice. He goes through, this is still from the brief, not the court, this is Brandeis' brief. He goes through the liberty of contract and the idea of police powers, and he purports, he says he's just applying Lochner. Such a law will not be sustained if the court sees it has no real or substantial relation to public health, safety, or welfare, or that it is an unreasonable, unnecessary, and arbitrary interference with the right of the individual to his personal liberty. Right? So he's just straight majority. But then he suddenly starts channeling Harlan's dissent. But he says, on the fact question, is it unhealthy to do X, Y, or Z? Is there a legitimate concern about health here? There you should defer. If the end which the legislature, and it's that same McCulloch language, if the end which the legislature seeks to accomplish be one to which its power extends, and if the means employed to that end, although not the wisest or the best, he's quoting Harlan, are yet not plainly and palpably unauthorized by law, then the court cannot interfere. The facts of common knowledge, which the court may take judicial notice. Judicial notice is a special term. This is how weird what's going on here is. Judicial notice is a special term that says a court can acknowledge widely known facts. Like, there was a civil war between 1861 and 1865, right? Or it's hot in the summer. It's usually used for like stuff that basic. So there's no need for the lawyers to argue about it. The only way, in terms of legal practice, traditional legal practice, to explain what the Lochner court is doing is saying they're taking judicial notice of specific terms of healthfulness or unhealthfulness of particular employments, which is weird. But Brandeis is willing to play along. Okay, the facts of which you may take judicial notice establish, we submit conclusively, there is reasonable ground for holding that to permit women in Oregon to work in a mechanical establishment more than 10 hours in one day is dangerous to the public health, safety, morals, and welfare. Police powers. All right. Brewer, 9-0 for the court, accepts Brandeis' argument. And so what we have to make sense of is that we have justices who voted to uphold the segregation law in Plessy, voted to strike down the labor regulation in Lochner, and voted to uphold the labor regulation in Mueller. Does everybody see why this is problematic? It doesn't remotely break down to simply pro-government or anti-government or pro-regulation. So what does Brewer say? He says, look, this stuff, these scientific studies, they're not really what lawyers are supposed to do, but the legislation opinions referred to in the margin, it's the margin. The brief is 2 pages long. The other 105 pages is this other stuff. In the margin of the Brandeis brief may not be, technically speaking, authorities, not legal authorities. Yet they are significant of a widespread belief that women's physical structure and the function she performs in consequence thereof justify special legislation. Why? Now notice the shift that's going on here, as I put in the italics. Right? It's not any longer about saying, does this fit a common law recognized traditional legal concept? It's about an empirical evaluation of reasonableness. First of all, women are in an unequal position. Remember the part where bakers didn't need protection from the state? The argument here is that women do. History discloses the fact that women has always been dependent upon man. He establishes control at the outset by superior physical strength, and this control in various forms has continued to the present. One of the consequences, women have fewer economic opportunities. Between female employees and employers, we will recognize an inequality that we would not recognize between male employees and employers. Education was long denied her, and while now the doors of the schoolroom are opened and her opportunities for acquiring knowledge are great, it is still true that in the struggle for subsistence, money, she is not an equal competitor with her brother. And besides, women are delicate creatures. Yeah, I always get kind of scared saying this part. I grew up with 3 sisters. I know when to be scared. Though limitations upon personal and contractual rights may be removed by legislation, there is that in her disposition and habits of life which will operate against a full assertion of those rights. And in fact, joking aside, as you all know, it's absolutely true that in the workplace, to this day, women tend to be less assertive in claiming things they're entitled to. So this is not nuts, especially in 1908. So what we have here, says Brewer, is valid class legislation. And this is the beginning of what's going to be equal protection jurisprudence. It is wrong to have laws that benefit one group against another if they are similar. It is perfectly okay to have laws that treat people differently if they are not similar. Example, no one thinks there's a problem with 5-year-olds not being allowed to drive cars. 5-year-olds are not like 30-year-olds, right? Age is a classic example. Doubtless there are individual exceptions, but looking at it from the viewpoint of the effort to maintain an independent position in life, she is not upon an equality. Differentiated by these matters from the other sex, she is properly placed in a class by herself. Right, so this is legitimate class legislation. Where the hell is page 9? There we go. I know, I'm running over. I'll be done in a minute. 2 at the most, I swear. And having gone to all these lengths to show it's legitimate for the state to want to protect women because women are in a weaker position and more vulnerable, he then adds the public concern. She is so constituted. Her physical structure and a proper discharge of her maternal functions, having in mind not merely her own health, but the well-being of the race, justify legislation to protect her from the greed as well as the passion of man. 319 on the right, middle of the long paragraph there. We could spend a few minutes just unpacking what the use of the word race. It's the American race he's referring to. But let's leave that aside. All right. So, the test in this period is a reasonable exercise of legitimate powers. The test for legitimacy. What's the test for legitimacy? Well, this is that question of what are the restrictions on police powers. One way to read it is there's a rule against new police powers. There's a long-standing tradition of laws protecting female employees. There isn't a long-standing tradition of laws protecting male employees. So the 14th Amendment, by this argument, is a fundamentally conservative proposition that says states may not go beyond what they've always done in the exercise of police powers. And the claim of progressives that new economic conditions require new things doesn't matter. So it doesn't diminish what was already there, but it preserves as the boundary of state authority traditional police powers. And therefore, rights of liberty of contract extend right up to that boundary. And anything any further than that would be an infringement on your rights. What's a reasonable exercise? Well, right? Reasonable has to do, as we said, with empirical analysis and so on. Here's why I think this isn't quite enough and why we need one more piece. And here's the piece that we're missing. Go back to what I said was the core line in Lochner that gets overlooked. There can never be a legitimate public interest in regulating economic relations. Why not? Well, this is right around the time that the American Economic Association is created. A field called economics has literally just been invented. So has the field called sociology and the field called political science and the American Historical Association. All of these are formed in the same 20-year period. The first social science, the first PhDs are not given out until only one generation before this. The idea of social sciences, in other words, for this older generation of justices and other people, the idea of something called the economy is a weird, radical new idea. The idea that there could be a public interest in the economy simply doesn't exist. The idea that economic relations in New York may affect economic behavior in California, that there is a system, and that a large enough perturbation at one point of the system will affect in the others, is simply missing. What the progressives are pushing is not radical forms of regulation so much as radical ways of thinking about society and the economy. And to my mind, at least, this is my suggestion, that helps fill in the missing part of how do the courts in this period distinguish between legitimate traditional exercises of police powers and illegitimate novel exercises of police powers. And it goes back to ordinary law, the language of ordinary law. How was public interest understood in the common law? So we are back where we started. Ordinary legal concepts are providing the content for constitutional regulations. They're just doing it in a context that seems very, very strange because to all of us, from our present perspective, it's obvious that everything has changed. It's obvious that the American system of economic relations in 1905 is not the same it was in 1787. But to the mind of lawyers, it's not. This is going to lead, as it says at the very end here, to the greatest political constitutional crisis of our history, but I'm already over time, so I'll pick it up next time.